seated.
Welcome to Talk Law Radio with attorney Todd Marquardt of the Marquardt Law Firm at marquardtlawfirm.com.
Welcome to Talk Law Radio. I'm Todd Marquardt. On the radio, on podcasts everywhere, on Facebook Live, on YouTube, and on talklawradio.com. If you know of a great guest or you'd like to be a guest, go to talklawradio.com. There's a button there that you click that says want to be a guest, and just send me a little bit of information about you and about what you want to talk about with me. And we might have you on the show on Saturdays at 11 o'clock in the morning. If you're already listening Sundays at 4:30 in the afternoon, check in with me on Saturday mornings where I have engaging and inspiring guests to talk about some aspect of the law that I think needs to be explained or that some people are having trouble with. Today we're going to be talking about probate and estate law, especially the law of wills and testamentary intent. Before we get started talking about the law, let's begin with prayer. Dear God, thank you for this day and for all the gifts and blessings that you give to us. Please forgive us for our sins, for our mistakes, for doing the wrong thing or failing to follow your will. Please help us understand the will you have for our lives, and help us to understand how our last will and testament can serve as our legacy for our family and beneficiaries. Please help us to do everything we do for the good of your people, for our own good, and for your glory. In Jesus' name, amen. Now it's time for you to listen to me talk about the law on the radio. And today we're talking about wills, last will and testaments, and testamentary intent. There's a court case that helps explain all of this, and so it's a good story to illustrate the principles of the law and how it might help you. But just remember that I'm not giving you legal advice, because legal advice must be tailored to the specific circumstances of each case, and laws are ever changing, and so the information I'm providing today should be viewed or heard as general in nature, educational, and informative only. The title of the case is Estate of Pauline, Moran, Allen, and it's a court case about a will. And I learned about this yesterday. I went to a conference in one of the Houston suburbs. It's been a long few days. I left after work on Thursday, got in late Friday, woke up early Friday, took the whole class, and then came home last night. So it was a lot of driving. I was in Houston, and I learned about this case that illustrates the principle of testamentary intent. There was a will, a written will, that the validity of it is not being challenged. The cast of characters is Pauline Moran Allen, the deceased person, Leonard, her son, who was appointed executor, Dolly, the daughter, who was contesting the codicil, and there were two other children that were not named and did not pose any contest. There was a trial proceeding to determine if the codicil was valid, and the trial court granted summary judgment allowing the will to be probated. The court found that there was no genuine issue of material fact to Dolly's contest, found that there was no ambiguity with regard to the deceased person's intent for the codicil to be a valid codicil. The court found that Leonard was entitled to probate the codicil, and they were admitted to probate the original will and the codicil. A codicil is like an amendment to a will. See, back in the olden days, when everything had to be typed. Believe it or not, my mom used a typewriter, and so I got to play with it every now and then when she wasn't using it. I even have an old-time typewriter that was my mother-in-law's grandfather's typewriter that he used when he worked at the rail station in southern New Mexico. That's just an aside. What I was getting at is that wills were typed, and so if you wanted to amend just a specific provision, you would call that a codicil instead of retyping the whole will, because that took a long time. A codicil has to be created and executed in the same way that an original will does. Has to be signed, has to be witnessed, and the codicil has to be the same way. But we're going to learn another element that isn't even in the code. Let me go to the code first. In Chapter 251 of the Texas Estates Code, Section 251.001, who may execute a will, says, under the rules and limitations prescribed by law, a person of sound mind has the right and power to make a will if, at the time the will is made, the person is 18 years of age or older, is or has been married, or is a member of the Armed Forces of the United States, an auxiliary of the Armed Forces of the United States, or the United States Maritime Service. Interests that may pass by a will, subject to limitations prescribed by law, a person competent to make a will may devise under the will all the estate, right, title, and interest in property the person has at the time of the person's death. A person who makes a will may disinherit an heir and direct the disposition of property or an interest passing under the will or by intestacy. It has to be written, signed, and attested. Except as otherwise provided by law, a will must be, number 1, in writing, number 2, signed by the testator in person, or by another person on behalf of the testator, in the testator's presence, and under the testator's direction, and attested by 2 or more credible witnesses who are at least 14 years of age and who subscribe their names to the will in their own handwriting in the testator's presence. The testator is the person that's making a written testament. That's their will. So that's the statute. Going back to the case of Pauline, Moran, Allen, the dispute is between Leonard, the executor, and Dolly, the daughter contestant. So here's what the codicil said. Well, actually, the codicil constituted 13 separate writings, but I'll refer to it as just the codicil, even though it was 13 separate writings. It was dated. It says Pauline Allen's statement, December 27, 2002, beginning with 4, Leonard Allen, china cabinet that Bro Lewis Moran made, parentheses, walnut, old sewing machine, parentheses, pedal machine, Mama Minnie's old machine, mule, red 4-wheel utility vehicle, John Deere tractor, bedroom suite in room where Jimmy used to sleep, upright deep freeze, all land, cattle, and home which will not be divided, blue willow china, old typewriter, the other china cabinet, big red wagon, old coin collection and cedar chest in front room, butane tank, Garney Allen's law pistol, Leonard may cash the bonds, Cattle may be held or sold to pay expenses. Dining room table. Signed, Pauline Allen, 12/27/2002. Witnessed by David Broomfield and Beverly Johnson. The issue here is whether this codicil is valid. The will, the original will, was to divide up everything between the 4 children. The issue with the codicil is that it purported to give specific personal and real property to Leonard only. Leonard offered to give $100,000 to each of his siblings, and Dolly refused. So this codicil was handwritten, whereas the will was typed, witnessed, notarized. There's no question about the validity of the original will. One of the questions about the validity of the codicil is that it was wholly in her handwriting, or at least so it would appear without delving into the facts. But the way that these papers were arranged, there was this long list of all those things I just read, and then it had Pauline's signature diagonal across the page, whereas the list of everything was neatly printed across the page, as you would expect. And then the witnesses signed in the lower right-hand corner. So there was suspicion about whether the list was actually in Pauline's handwriting, but that doesn't decide the issue on the case. Oh, the codicil was not titled. It didn't say last will, it didn't say codicil to last will, so that's an important fact. The suspicion by Dolly was that this was just a laundry list. We don't really know what it was to do. It didn't say that this was a codicil. She never said, I give Leonard all of these things upon my death. So the law, the court case, lawyers will talk about testamentary intent. Was it Pauline's intention to make a gift upon her death by writing this laundry list? And one of the cases cited by the Court of Appeals in Tyler says, an instrument is not a will unless it is executed with testamentary intent. And they cite an older case, Henson versus Henson from 1955. A handwritten codicil must have testamentary intent. And so this case that is cited by the Court of Appeals was also about the same issue, whether the deceased person in that case had testamentary intent. But we'll come back to that later so that we don't get confused about which case I'm talking about. There's a couple more cases that I'll come back to. The Court of Appeals said testamentary intent depends on the maker's intention to create an irrevocable disposition of her property to take effect after her death. A court's first duty is in a proceeding to probate a will or codicil is to determine whether it shows testamentary intent. The introduced writing must contain an explicit statement declaring that the writings are wills or codicils, or that the property division to take place only after the decedent's death. There must be evidence that the testator intended that very document at issue to be the instrument that actually makes the disposition of the testator's property. A writing that merely evidences an intention to dispose of property is not a will or a codicil. It has to actually be a disposition of property upon death. So here, Dolly complained that the codicil document did not contain any words evidencing that Pauline intended for these writings to actually dispose of her property upon her death. The court said, the intent of the testator must be ascertained from the language used within the four corners of the instrument for probate. So here, remember I said it was these 13 separate writings collectively called the codicil. So just looking at those papers, the court has to decide, are there some words on there that shows testamentary intent? When there is no dispute as to what the written words in a codicil mean, extrinsic evidence cannot be received. So here, on those 13 pages, there was no dispute about what the words meant. Extrinsic evidence cannot be received to show the testator intended something outside of or independent of those words. Extrinsic evidence is evidence from outside of the document. Extrinsic means outside. Evidence can't be received to add words to the codicil. Evidence cannot be received to contradict the language in the codicil. Evidence cannot be received to take away words from those in the codicil. The court said without express language establishing testamentary intent, a writing is not a will and cannot be admitted to probate. In determining whether there's testamentary intent, the question is not what Pauline intended to write, but the meaning of the words that she actually used. There were two words in the document that could have been used to operate something, to cause action of some sort. And those were the words statement and for. We must determine whether either of these two words establishes Pauline's testamentary intent. I want to take a break here to let you know that Marquardt Law Firm sponsors the show, and attorneys at Marquardt Law Firm focus on business and estate law, including last wills, living trusts, and tax-protected inheritance plans. Also, new businesses and old businesses which might have issues with corporations, contracts, LLCs, family limited partnerships, and we can represent those who are facing problems from lack of planning, like in county court, district court, or probate court. Okay, back to the case. We're talking about testamentary intent. And we're analyzing, or the Court of Appeals is analyzing, a codicil to a will, and the words that we're going to define and determine whether or not they were operating as testamentary intent. The words are statement and the word for, F-O-R. We first look at the word statement, which is defined as the act of stating or a declaration. That was found in the American Heritage College Dictionary. The court said there is nothing in this definition that relates to when the transfer of property is to take place, such as at the time of Pauline's death. Further, the word statement has a legal meaning in the context of evidence and criminal procedure, but in and of itself has no legal meaning in the probate context. The word for is used to indicate the object, aim, or purpose of an action or activity. Definition coming from American Heritage College Dictionary. The court said for is also used to indicate the recipient or beneficiary of an action. Court said neither of these definitions indicates when the action or activity will take place, or when the beneficiary will receive the object. For testamentary intent to be established, the writings must clearly indicate that the transfer of property is to take place after Pauline's death. Hopefully you are understanding that this has to take place after Pauline's death. The word for does not indicate when the transfers are to take place, and more particularly does not indicate that they will take place after Pauline's death. Never says that. You have to have the right words. The court noted that the writings do not contain language ordinarily used to make a disposition of property, like words that lawyers usually use. Nowhere in the writings did they find testamentary language, such as grant, devise, nor were there any words from which a bequest can reasonably be inferred. It was just a laundry list of personal property, real property. No amount of outside evidence could supply the absent testamentary intent, and in the absence of express language evidencing that, the writings are not a codicil. Because neither the operative words in the 13 writings, statement or for, indicate the property division will take place, and there is no other declaration that such division will take place after Pauline's death, the court held the writings lacked testamentary intent and failed to constitute a codicil. The trial court made an error in granting the motion for summary judgment, and it was reversed. Let's go back to a couple of those court cases that were cited that can serve as other examples of testamentary intent. In Henson versus Henson, there was a letter. It was dated. The title of it said, "Supplementary to my last will. It still stands as is. To my wife, Ethel May Henson, my will is in briefcase zipper comp. Copy to wife. Copy to my son, J.W. Henson Jr. Everything is yours, darling. Pay the home off. Sell my car. Have will probated at once. Go to Judge Ewing Boyd. Tell him who you are. He will give you all legal advice needed. He is my friend. Sell all my guns, things you do not need. Sell the home if you like, but buy another one where you wish to live. Take care of everything I leave you. Will need it all. I love you, darling, so much more than my own life. Bye, J.W. Henson." Here the court said the testamentary intent does not depend on the maker's realization that he is making a will or upon his designation of the instrument as a will, but upon his intention to create a revocable disposition of his property to take effect after his death. It is essential that the maker shall have intended to express his testamentary wishes in the particular instrument. Here, the handwritten codicil begins with the words, "Supplementary to my last will and testament." It still stands as is. But the court said that this negates any intention to revoke or modify any of the provisions of the typed will. At the very outset, the decedent conveys the idea that he has something in mind other than the making of a testamentary disposition of his property. He has already executed an instrument which he thinks is a legal will, and it still stands as is. In the body of this document, he used the words give, devise, and bequeath, and it is my will, and directed the payment of debts, appointed executors, and revoked former wills. That was in his actual will document. The handwritten instrument did not affirmatively state that it was intended or declared to be a will, and does not contain language ordinarily used to make a disposition of property. The remaining provisions regarding the preservation of the property and the sale of various items thereof are in the nature of suggestions and advice to the wife for guidance in the management of the estate he had attempted to devise to her by the will. So be careful of the words that you use, because the court might say those are suggestions and advice. Another legal term could be precatory, just meaning not operative, but as a side note. So this is good information when you're thinking about making your will. Of course, it's recommended that you go to a legal professional, an attorney that focuses on wills and trusts. You heard it here on Talk Law Radio. I'm Todd Marquardt. I'll talk to you later.
This has been Talk Law Radio with attorney Todd Marquardt, brought to you by the Marquardt Law Firm. You can learn more at marquardtlawfirm.com. And be sure to listen to the full Talk Law Radio show Saturday mornings at 11 on 9:30 a.m. The Answer.
Each week, attorney Todd Marquardt talks about the law. His mission with the Talk Law Radio show and podcast is to help you discover your legal issue blind spots. In the beginning, God had one law: don't eat from the fruit of that tree. Then came the 10 Commandments. Now we have federal, state, and municipal lawmakers that won't stop creating new laws that might impact you without you knowing it. Listen to the show and drop a line on Facebook or email host@talklawradio.com and let the host know what you think of the show, the topics you want to hear, and whether you want to be a guest.